Call the Senate to order. Sergeant Arms will please secure the doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, we are very pleased this morning to have Reverend Zachary Wheeler from the Bethesda United Methodist Church across the bridge in Salisbury, Maryland, guest of the distinguished senator from the 38th District. Please rise for the invocation.
Would you join me for prayer? Holy God, we come to you today with humble hearts, asking for your blessings upon the members of the Maryland State Senate. As they convene to serve the people of this great state, we ask for your wisdom, guidance, and protection. May these leaders approach each decision with a spirit of compassion and understanding, recognizing the needs and concerns of all Marylanders. May they work together with respect and unity, striving towards common goals that benefit the whole community. We pray for their health and well-being, both physical and mental, as they carry out their duties with diligence and dedication. May they find strength and inspiration in the knowledge that their work has the power to positively impact the lives of many. May their actions be guided by the principles of justice, equality, and fairness, as they strive to make Maryland a better place for all who call it home. May they be mindful of the power and responsibility that comes with their positions and use it with integrity and honor. We ask for your blessings upon their families of these leaders, who may feel the weight of their loved ones' responsibilities. May they find comfort and peace knowing that their sacrifice contributes to the betterment of the state and its people. And as this Maryland State Senate convenes, we ask for your presence to be felt in their deliberations, their decisions, and their actions. May they be a beacon of hope and progress for all who look to them for leadership. We offer this prayer, and with gratitude for their service as we connect with your faith and your divine guidance. Amen.
Thank you. Appreciate that. Thank you very much. Chair recognizes the senator from the 38th District.
Good morning, Mr. President, and I'm just delighted that Reverend Zach Wheeler and his two beautiful daughters, Madison and Cassidy, over here. Stand up, girls.
Welcome.
And they've come up from Salisbury, Maryland, and Reverend Wheeler was a youth minister before becoming Reverend at his pastorate, his current church, Methodist United in Salisbury. I also wanted to point out, it's appropriate with your youth background, that your wife is a Wicomico County school teacher, a reading coach. So it's certainly appropriate to have you up here with your daughters, and I ask that the good Reverend's prayer be journalized.
Absolutely, without objection, Senator, we will journalize the Reverend's wonderful invocation this morning and thank him for bringing his daughters here and for joining us this morning. We're very pleased to have you all and thank you all. All right, has everyone recorded their presence? Look at that. Look at that. For the first time this year. The clerk will take the call. With 47 members present and in the chamber, the Senate of Maryland both has a quorum and is now in session. It is the 445th legislative session with a full Senate. It's a good day. It's a good day. We're rocking and rolling, cooking with gas now. All right. Do we have any other introductions? Yes, Chair recognizes the senator from District 6.
Thank you, Mr. President. We have a church that prays for this Senate and prays for all our legislators, prays for the governor, prays for you, Mr. President, and prays for the Speaker. And they're visiting with us today. My home church from Dundalk, Calvary Baptist Church.
Oh, wonderful.
They're part of a school, and they do some really great stuff for our community. They have over 100 missionaries that they reach out throughout the world. We just had a missions conference, and every year we do record amounts of every year, Mr. President, to give to those that are reaching the world and reaching the love of our Lord. And I would like for Calvary Baptist students to stand and let's Senate give them a warm Senate welcome. Thank you, Mr.
Welcome. Thanks for being here. Thank you. Welcome. All right. Do we have some other introductions? Mr. Minority Leader, do we have an introduction? No? Introduction? Oh, yes. Oh, Yes, Chair recognizes the Senator from Lower Eastern Shore.
Thank you, Mr. President. This is a big day for the Lower Shore with both our guest chaplain, but also statewide, because we have women from all over the state, part of the Maryland Federation of Republican Women, that you will see with their red scarves. So if they will all stand, we have the women that have come over from across the state here engaging with us on priorities, and I want to thank them all. I'm actually a member of this organization at the county level, and just really delighted that they would take the time to come here and engage with us all day. If we could have a very warm Senate welcome for all of the members of the Maryland Federation of Republican Women.
Welcome, welcome. Thanks for joining us today. We appreciate your presence. Senator from 40th District, do we have our... Yes, Chair recognizes the Senator from the 40th District.
Yes, thank you, Mr. President. In the gallery today, we have students from the Seed School of Baltimore. I can't see them. They may oh, please stand up and recognize the Seed School of Baltimore City.
Welcome, Seed School. Welcome, Seed School. It's a great, great, great school. Yes, Chair recognizes the Senator from the Middle Eastern Shore.
Thank you, Mr. President. I'd like to introduce my shadow for the day, who's on the floor with us. He's been an intern in our office. Spencer, please stand up. His name is Spencer Rada. He's a freshman at Norwich University. He was the president of Easton High School. He led the NJROTC, and he's a direct descendant of the Rebecca T. Ruark, which is a moving national historic landmark tied up at Tillman Islands. Welcome, Spencer. Thanks for being here.
Welcome, welcome. Hope you enjoy your experience. Welcome. Any other introductions? Any other introductions? We do have, oh yes, Chair recognizes the Senator from Prince George's.
Thank you, Mr. President. I can assure everybody in this room that we are so happy. We are delighted and overwhelmed with joy to have back sitting on this floor this morning the chair of the Budget and Taxation Committee, who looks good and is doing so well. Let's give him a round of applause.
Welcome back. Welcome back. Yes, Chair recognizes the Chair of Budget and Tax.
Thank you all very much. Just a couple quick reflections, Mr. President. First off, I have so much gratitude for my family and my friends, and in particular, standing in this body. You know, we often talk about the family that is the Senate, and I certainly felt it these last week or so. I am so grateful to all of you for your thoughts, for your prayers, and it has really meant a great deal to me. And then I have to say this because I think we're all a little bit of policy geeks out there. As I was laying in the hospital bed, I was thinking to myself how grateful I am to have insurance, how grateful I am to have the availability of quality health care. And it really reaffirmed to me what we do here and our responsibility to stand up and do the very best we can for everyone, no matter who they are, to have that right of a quality health care. So, Mr. President, I'm just grateful. I'm glad to be back. Thank you all very much. I appreciate you all.
Well said. Well said. Well said. We have another happy note today, another 1983er in the house here today. We have a birthday. Oh, wait. Okay. Just a moment. Well, maybe we'll do that in an announcement in just a moment. Give us a second. Today, the big 4-0 for our senior trooper, Steve Stewart. Happy birthday, sir. I promised him I would not make that announcement, so to be very clear. Yes, exactly where he wanted to be, right here on the 40th birthday, right? This is it. The dream has come true, trooper. All right. Any other introductions or business before we jump in? If not, let's go ahead and waive the reading of the journal from the prior legislative day. We've got layover bills, calendar number 4. Clerk will read the bill.
Senate Bill 144, Senator Feldman, Public Utilities, Energy Efficiency and Conservation Programs, Energy Performance Targets and Low-Income Housing. Question is on the adoption of the one committee amendment and the favorable report.
Chair recognizes the chair of the committee.
Thank you, Mr. President. Senator from Charles County has a floor amendment. It relates to a sort of an area of the law that we had taken some action out of committee dealing with the Attorney General and some constitutional questions. So I've asked the gentleman before we take up that floor amendment to get some AG advice. So with that, I'd ask we special order this till the appropriate time tomorrow, and we'll take up the bill at that time. And I know there's a layover from Senator to my left. So.
Excellent. All right, so we will, the Senator's move to special order the bill to the appropriate time tomorrow. Are there any objections to the Senator's motion? Without objection, so ordered. The bill will be special ordered to the appropriate time tomorrow. We've got another layover calendar. This is number 5. Clerk will read the bill.
Senate Bill 390, Senator Lewis Young, Provision of Veterinary Services, Routine Medical Care, and Rabies Vaccine. Question is on the adoption of the 3 committee amendments and the favorable report.
All right, question for the bodies on the 3 committee amendments. Chair recognizes the bill sponsor.
Thank you very much, Mr. President. Just a quick refresher, Senate Bill 390 expands the scope of practice to some individuals who would be able to administer rabies vaccines in our shelters, which are very overcrowded. Previously, there were 3 amendments. One was technical. The other asks the veterinarian community to carve a path forward to license out-of-state vets and develop an implementation plan. I now have a floor amendment which will address the concerns of the veterinarian community about the proper training and capability of those individuals administering rabies vaccines. The floor amendments.
Senator, just give us one moment. We have to accept the committee amendments and the report before we take the floor amendment. Let's go ahead and take up the committee amendments first. Is there any discussion on the 3 committee amendments? Any objections? Without objection, the 3 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Senator has an amendment. We've collected the amendment pages. If we could, the first amendment collection or distribution process, the pages will distribute the amendment, and we're going to do it as quickly as possible. If senators aren't looking, just feel free to drop it on their desk. But we do want to make sure that they have a chance to review it. Thank you. Give us just a moment, Senator, for members to get a hold of the amendment. All right, Senator can explain the amendment.
Thank you very much. The First Amendment authorizes the State Board of Veterinarian Medical Examiners to issue a license to an animal control facility to administer the rabies vaccines. And the Second Amendment defines what drugs are. And the rabies vaccines should be administered in accordance with existing protocol. I believe that's it. Thank you.
All right, Senator moves the amendment. Any discussion on the amendment? Any objections to the Senator's amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Yes, Chair recognizes the Senator from Prince George's.
Thank you, Mr. President. I do have an amendment. It's simply a sponsor, co-sponsor.
All right, if we could just collect the amendment.
My wife loves this bill, and I do not want to be in the doghouse. Thank you.
All right, pages, if we can collect the amendments and distribute it quickly. It's a sponsor amendment. Senators, if you see it on the desk, are there any objections to the Senator's sponsor amendment? Let me just double check. Always good to double check it's onto the right file. All good. All right, any objections? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 390 is hereby ordered printed for third reading. We've got another layover bill. This is calendar number 6. This is, clerk will read the bill.
Senate Bill 37, Senator Waldstreicher, Criminal Procedure Expungement of Records, Waiting Periods, Regime Act of 2023. Question is on the one committee amendment and the favorable report.
Question is on the one committee amendment. Chair recognizes the minority leader on the amendment.
Thank you, Mr. President. May the floor leader yield for questions,
The
please?
floor to yield appears so. Senator may proceed.
Happy to. Thank you very much. Just very quickly, can you explain an expungement, what that actually is with respect to a crime, a violation, and what it actually is that?
In most cases, expungement is the physical obliteration of all records relating to the conviction of a criminal offense, and in some cases, a non-conviction.
Okay, so obliteration, it never happened, in a sense, is what you're saying. From a record from a documentation, records, an expungement will essentially say that it never happened, correct?
Conceptually, it doesn't necessarily say that it never happened, but for all practical purposes, that is what is happening. For certain record keeping, a record will exist when the information is passed on, for example, to the federal government. The federal government runs background checks for certain circumstances, and even if it is physically obliterated on our side, that information has already passed to the federal government. So when they do certain background checks, that information will continue to exist in their database, but not ours.
Okay, thank you. And then with respect to the amendment, so the bill came in, and what you're doing, essentially trying to do is shortening the period on how long you have to wait to, is it petition for expungement? This is a proactive event?
That's exactly right. It requires a petition from the person seeking expungement. As you may recall, in 2015, this assembly, on a bipartisan basis and with working with the previous governor, created a list of offenses that we believed should be expungible. The bill in front of you does not alter that list in any way, shape, or form. But the waiting periods that we implemented in 2015 are quite long. 15 years for certain nonviolent felonies, 10 years for misdemeanors. Those are out of step with what the rest of the country is doing. This bill reduces those waiting periods.
Okay, but as one of the amendment talks about felonies, though, correct?
So the amendments, so as the bill came in, felonies would be reduced from 15 years to 5 years, and misdemeanors from 10 years to 3 years. The will of the committee was that those waiting periods were too short and were not appropriate. And so we amended the bill so that most of the nonviolent felonies that are currently expungible, instead of being 5 years, would be 7 under the bill as passed, and most of them, or all of the misdemeanors that came in at 3 years would now be 5 years. And so that is where the committee landed on a unanimous basis.
Okay, you spoke about misdemeanors, then you spoke about nonviolent felonies. What about violent felonies?
Violent felonies are, as a whole, not expungible under current law. This bill does not change that.
This doesn't change it. So are there any other offenses that are not expungible? You said violent felonies. Anything?
There are lots of offenses that are not expungible. It's violent felonies, some misdemeanors. There's a PBJ that is not expungible. So
this bill doesn't change that list of offenses that are non-expungible. Okay. Thank you very much, Mr. President. Thank you.
All right. Thank you, Senator. Question is on the one committee amendment. Yes, Chair recognizes Senator from Anne Arundel on the amendment.
Yeah, just a quick question to the floor leader.
Senator may proceed.
Some crimes have first-time offense get this sentence, and then second and subsequent have longer. When you expunge something and that person commits another crime of the same type, do they get sentenced as a first-time offender or second-time offender as far as the penalties go?
That's a good question. After the waiting period, and just to be clear, the waiting period begins after the sentence and parole or probation of the individual convicted. So after the waiting period and after the expungement takes place, you then reset. And so that would be a first conviction. Now, just to be clear, during the waiting period, if you are convicted of another offense, there is no expungement. In other words, if you get convicted of another offense during your expungement waiting period, you become ineligible for expungement at all.
Okay, so just to be clear, somebody commits a crime, they do their time, they go through the waiting period to get expunged, and then the waiting period. They commit it again, it's been reset, so they would be sentenced as a first-time offender.
That's exactly right.
All right, thank you, Senator. Are there any further discussion on the committee amendment? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 37 is hereby ordered printed for third reader. We've got another layover calendar. This is number 7. Clerk will read the bill.
Senate Bill 290, Senator Smith, Office of the Attorney General, Independent Investigations Division's authority to prosecute. Question is on the adoption of the 3 committee amendments and the favorable report.
All right, question is on the 3 committee amendments. The 3 committee amendments. Any discussion? Any objections to the 3 committee amendments? Without objection, the 3 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? Chair recognizes the minority leader on the report.
Thank you, Mr. President. If the floor leader could yield, please.
Floor Leader Pearceau, Senator may proceed.
Thank you very much. I know that the General Assembly has been waiting for a lot of bills that we're going to deal with crime this session. I guess this is the first one, but this is crimes that police officers commit. Is that what I understand this to be?
No, these are officer-involved deaths.
Officer-involved deaths.
They're incidents that are likely to cause death. So
explain what does that mean? What does that mean?
So if there's a car chase, for instance, there was one a couple of weeks ago at the end of February in Baltimore City. Officer was in pursuit of a car collided into another car. They both crashed into a building. The facade collapsed down on them. There was a death there. That would be an officer-involved death. Any death or serious or injury that's likely to cause death that involves an officer is included under this bill.
And so what was happening previous if this bill is not in existence?
So right now, last year or 2 years ago, we set up an entity that would do independent investigations. So this office, in the Office of the Attorney General, does the investigation of those officer-involved deaths from soup to nuts. So they do the investigation and then they publish a report. After they publish a report, the state's attorney in the jurisdiction in which the event occurred has 15 days. They have 15 days to turn over the report, and then at that point, the state's attorney has the ability to prosecute or decline to prosecute. This bill closes the loop and gives the attorney general the ability to make that decision and prosecute or not prosecute instead of leaving it with the state's attorney.
Why is that necessary?
Because there's an inherent conflict. I mean, that's exactly why we passed the first bill to do independent investigations. Now, we had great testimony by our attorney general in our committee about this. State's attorneys and law enforcement officers have very close relationships, not inappropriate relationships, but close nonetheless. And there's an inherent conflict when there's an incident in which there's an officer involved in something that prosecutor is now responsible for making a decision as to whether to prosecute that officer. So we're closing the loop on this reform, decoupling this process and getting rid of the conflict that's inherent in the current system.
So did the state's attorneys all come in favor of this bill?
No, actually, the state's attorneys took a position against this bill, as they did with the prior bill that gave the investigations unit.
The state's attorneys feel that they are able to handle this either amongst themselves, or some of them have agreements that if this situation were to occur, that an adjoining or nearby county would actually lead that investigation and prosecution.
No,
right?
to my knowledge, only one has an MOU, and that's Howard County and Montgomery County. And so they have an MOU. But that again, we've talked about this before, but that system wouldn't work across 24 jurisdictions because jurisdictions are of different sizes, the caseload is going to be different, the resources are different, and so you can't really plus that model up. You'd have these weird forced marriages. It just wouldn't work as a statewide model. Believe me, we looked into that several years ago when we went through this first iteration of police reform.
So tell me what's not working right now then. What's not I mean, why is this necessary? What's not working?
What's not working now is that you have independent investigation, which is, I think, if anyone here can Google this, Google IIDOAG prosecution, and you'll see that this great website has a dashboard of accessible reports. You've got the videos there. You've got essentially everything from soup to nuts. It's all accessible and it's very transparent. Everyone across the state, anyone with an internet connection can access it. So that's independent and it's been kind of like the model of how government should actually work. I think it's a fantastic model of how that works. But the problem is when the report is finished, and once that report's finished, they've got 15 days to give to the state's attorney. The state's attorney then still has control over whether to prosecute or not. And again, that relationship, that close relationship, still exists at that part of the process. Case in point, there was one jurisdiction that chose not to move forward for the prosecution before the investigation was even complete. That particular state's attorney didn't request any evidence, didn't seek any evidence out. It just said, look, I'm not moving forward with this prosecution, despite not having any information to make an informed decision. That's an exact case as to why this reform is necessary and why this process is not working and some of the flaws that can happen under this current regime.
You're saying a state's attorney decided not to move forward with something because they had all the information they needed. They didn't think that they needed information.
They didn't think they needed all that information. They were not in receipt of the report from the Independent Investigations Division from the Office of the Attorney General. He made that decision before getting that report.
So this Independent Investigations Division falls within the Office of the Attorney General?
That's right.
Led by an individual?
So there's a chief, and that office has grown. I can give you the specific numbers. They started off with just 3 people, but now the office has grown. But there's a chief. And she is eminently qualified, has a depth of experience not only in the Department of Justice but also several jurisdictions across the nation. She's prosecuted cases like this in 12 jurisdictions across the nation. The attorneys that they've been able to recruit are highly qualified. In fact, we had following up on our hearing, the Attorney General followed up just to, answer that specific question. And I'll just read a little bit from it. Multiple IID attorneys have spent their careers prosecuting these cases, both in Maryland and across the country. Our chief, Dana Mulhauser, spent her career as a DOJ and local prosecutor investigating and trying excessive force cases in a dozen different states. Our deputy chief, Renee Joy, headed the public integrity unit at the Prince George's County State's Attorney's Office, as well as being a homicide and white-collar prosecutor, and it goes on. So they've got a breadth and depth of experience at this, not only here in Maryland, but across the nation.
Do you know if this chief comes before executive nominations?
She does not, no. She is hired by the Attorney General, serves at the pleasure of the Attorney General.
So Attorney General is elected, state's attorneys are elected. This is just a higher but nobody takes consideration on the capabilities and qualifications.
Just like many of the divisions that operate under the Office of Attorney General, each division has a chief. Each division is hired and or fired by the Attorney General. The Attorney General is ultimately responsible for those decisions.
And you talked before about a officer involved killing, it had to be?
Or injury that's likely to result in death.
Okay.
There's another feature of this bill that we can speak to a little bit, but with permissive referrals, optional referrals from the state's attorneys. But
under this bill, is there anything that's done differently if an individual fires at a police officer?
It depends on what happens after that firing happens. So does that individual get killed? Is the officer killed? We changed the language to say individual and not civilian. So that would, if the officer passed away and the officer was involved in that exchange, then this process would kick in.
I guess what I'm asking is this seems to be targeting, obviously, law enforcement officers, right? What you're trying to do is find, I don't know if it's a better way, an easier way to prosecute or investigate law enforcement officers, right?
I wouldn't even say I would say that it kind of just moves this process away from conflict of interest and has a neutral fact finder and decision maker make those decisions, just removing it from that conflict. And so it's neither pro nor con for the officer. It's just independent. It's not weighted either way. Frankly, if I were a state attorney, I would not want these cases because they're political hot potatoes. They are enmeshed with conflict. I would be happy to see this responsibility to an entity that is not as conflicted as I would be.
But it also is very dependent on the individual that's in charge of this division. And this individual could have a history of prosecuting law enforcement officers more often than not, correct?
So one thing is you get to decide. The great thing about this division so far, and that's why I think it's really a model for government, is that all of that information is laid bare. You can read the reports, you can watch the video, you can make your own decisions. We as policymakers can make our own decisions. That's information that has never been disaggregated and presented to the people of Maryland ever before. We have more information to make informed decisions, including if we think that someone's being overzealous. If someone's being overzealous, that's going to be readily apparent, and it's our responsibility to correct that. So, the information speaks for itself. I think that's the benefit of having things being so transparent. You'll be able to identify someone that's being overzealous and unjust.
Okay. Thank you very much, Mr. Floor Leader. Thank you.
Thank you, Senator. Chair recognizes the Minority Whip.
Thank you, Mr. President. Mr. President, I wonder if I could follow up with one maybe point of clarification question with the floor leader.
Senator, yield for a question. Senator may proceed.
Thank you very much. You were in the last questioning. You were talking about MOUs in other counties, and you said only one county or two counties have an MOU.
Howard County and Montgomery County have an MOU, and I think if this type of incident happens, they were investigating each other's officer-involved incidents like this.
I'm quite confident that our county has done this in the past, and I know from my own research now that I represent a piece of Frederick County. I was looking into this before. I believe both of my counties I represent have an MOU with other counties to do this. So I'm not sure that that's accurate.
There's no formal MOU with those other counties, is what I've been told. But I'm literally only aware of two counties, Howard and Montgomery. Maybe it's an informal case-by-case thing. I'm not sure how that operates, but.
Okay. Well, I just wanted to be clear. I mean, whether there's a formal MOU, counties have been doing this for a long time, that they outsource so that they can, obviously the concern about conflict is a fair one, but other states' attorneys can come in and allocate staff and resources. Can I just ask you, you mentioned some of the staff in the Attorney General's office, and we never want to get into super personal stuff with staff and personnel, of course, but do they have experience prosecuting criminal law in Maryland?
They do. The woman from Prince George's County does, and yes, they do. So I don't want to read the resumes and.
No, I understand,
the answer is yes.
Okay, because I think my concern would be, and perhaps they have some experience, but will we be guaranteed that position will always be filled by somebody with criminal law experience, like dealing with criminal cases in Maryland? I think it's very important if you're going to have the Attorney General's office, which traditionally has not handled these kind of things. Are we going to have a guarantee? Is there anything in the bill guaranteeing that will always be the case?
There's nothing guaranteeing that, but except for the fact that, look, they're going to recruit and retain these individuals, and these are folks who are going to be naturally inclined to apply for these positions. This is the same thing that happens with the state prosecutor's office, which they do public corruption. And they do that on a statewide basis. They go through all 24 jurisdictions. That unit we stood up in the 70s, I believe. And the same thing. They recruit individuals that have this type of expertise, and they retain them. It's the same thing. This is not a novel concept.
And I guess finally, Mr. President, are we going to? Can you quantify how many cases we're talking about a year? Because it feels like a lot of work being done. I know there's more than two, but there are not hundreds. So, I mean, how many cases are we talking about in the state, roughly?
So there are 30 and 18 months. And that's if you go to that website, you've got a great dashboard. You can check it out. But I know I keep plugging the website, but all that information's right there.
Okay. It seems to me like we're taking a little bit of a bazooka to a gnat problem here, Mr. President. But I'll withdraw. Thank you very much.
All right. Thank you, Senator. Chair recognizes the Senator from the 42nd District.
Thank you, Mr. President. Would the floor leader yield for some questions?
Senator may proceed.
Thank you. Do you recall the Attorney General was asked why this bill is necessary at the committee hearing, and he said that it's inappropriate for a state's attorney to prosecute a police officer with whom the state's attorney may have worked on other prosecutions. In other words, a conflict of interest argument. Do you recall this as being the principal reason behind this bill?
The inherent conflict, yes, not that in particular case being the reason for this particular bill, but the inherent conflict.
The inherent
yes,
conflict between a state's attorney prosecuting a police officer in his county or her county with whom the state's attorney may have worked on other cases.
Correct. And can I read something too, just as a response? I mean, it was interesting when we were going through our reforms back in 2021. There was someone who's now the state's attorney for Baltimore City wrote an op-ed in the Baltimore Sun. And so that just to share with you that sentiment is shared across lines here. With this, I want to just read a couple of excerpts. With the state lawmakers considering widespread reforms to address police brutality, the role of local prosecutors in holding police accountable must be scrutinized. Then he goes on to talk about some of the other state's attorneys who oppose this idea. And he says that they maintain that local prosecutors are in the best position to handle police misconduct cases. However, this is simply incorrect. Local prosecutors lack the specialized expertise and independence to effectively prosecute and win cases against offending officers. He goes on. Further, local prosecutors seem unwilling to acknowledge the blatant conflict of interest their offices face in pursuing police misconduct cases. After all, prosecutors work with police officers every day. They bring cases and attempt to gain convictions by working together. That's by the current state's attorney from Baltimore City. So that sentiment is not only shared by the Attorney General, but several other folks familiar with this line of work.
But is it not correct that the current state's attorney from Baltimore City is opposed to this bill?
I don't have, I know that the State's Attorneys Association is opposed to the bill. I don't know how that individual voted.
Didn't we get testimony that 23 of the 24 opposed the bill and only one did not oppose the bill, and that one didn't take a position one way or the other?
That's correct. The largest jurisdiction in
Montgomery
the state.
County.
Yeah.
So based
the
on that
words
information, it sounds as if the state's attorney for Baltimore City is opposed to this bill.
The words are the words. I read the words into the record, and so maybe the state's attorney's evolved as he's assumed a different position.
Okay. So in my experience, our state's attorneys are quite cognizant of their need not only to be independent, but to be perceived by the people as being independent. Do you believe that our state's attorneys fail to appreciate conflict of interest issues?
No, I would never impugn their integrity in that sense.
Okay,
no.
and we've heard that in various counties they enter into MOUs with other counties. So, for example, if Montgomery County has a conflict of interest situation, the Howard County state's attorney comes into Montgomery County and prosecutes the case, and vice versa. In Howard County, if there's a perceived conflict of interest situation, the Montgomery County state's attorney comes into Howard County and prosecutes the case, correct?
Yes, and look, like I said, we looked at this model. I just don't think it's scalable with the difference in size and caseload of jurisdictions and resources. Also, I will point to...
Do we have a situation where this model has not worked? Where a state's attorney does not appreciate the conflict of
Senator,
interest?
if we could just ask and answer. So please don't interrupt the senator.
We have, I mentioned it earlier today. One jurisdiction that this prosecutor literally said, I'm not moving forward with this case without having all the information. I think that's the case. That's the case in chief in this case here. So yes,
okay.
There you go. It's on a platter.
I was asking about conflict of interest situations. Is it your contention that the Harford County state's attorney had a conflict of interest?
It's my contention that the Harford County state's attorney did not move forward with something absent a full picture and scope of what the case was all about.
Okay. Do you recall in our hearing, the state's attorney from Howard County made the following statement in his written testimony: "There is no merit to claims that prosecutors are unable to evaluate and hold accountable law enforcement officers within our jurisdictions. To assert that we, as the elected state's attorneys, would be biased and either incapable or unwilling to prosecute law enforcement officers in these cases under the appropriate circumstances is not founded in any facts." So can you cite any instance in which you believe a credible argument can be made that the state's attorney in a county ignored the conflict of interest and prosecuted the case anyway?
So look, I never said that anyone was biased, incompetent. I just think that there's an inherent conflict present here. And if we are going to do this reform, which this body made the decision to make these independent investigations, independent and nested within the Office of Attorney General, then we should complete this reform. We're either going to do it or not. So I do believe there is an inherent conflict in this process. I've given you a recent case that just happened last year. And so the answer is yes, there is an inherent conflict, but I would never besmirch anyone's reputation or their ability to prosecute cases, to exercise sound judgment, but there is an inherent conflict.
Well, let's talk about a real conflict that this bill would set up. So a couple of years ago, we passed a bill that provided that the Attorney General of Maryland would take exclusive responsibility for investigating these cases in which there was a police-involved death. So this Attorney General of Maryland is going to be the investigator in this case, and if this bill passes, he will also be the prosecutor. Now, under normal circumstances, the police department of a county investigates a case, and then the state's attorney in the county exercises his discretion to decide whether or not to prosecute. In this case, if this bill passes, you're going to have the Attorney General of Maryland conducting the investigation and then making the decision to prosecute the case. Isn't that a conflict of interest?
This is not a novel concept. I mean, look, this is exactly what the FBI and the Department of Justice does, and attorneys are always involved with these types of investigations. Attorney-led investigations, it's even a colloquial phrase in people that are familiar with this type of practice. And they're done in civil rights cases, money laundering cases, RICO cases, white-collar cases, and other complex litigation. So this is not a novel concept. The conflict exists when you have a strong working relationship with the subject of the investigation, not when there's the same entity is responsible for investigating and prosecuting.
So the state's attorney for Anne Arundel County, Ann Colt-Litis, provided a statement to our committee in connection with this bill. She said, "The irony of this proposed legislation is that if passed, the Attorney General would now investigate and prosecute these matters, making them no longer an independent agency. They would now wear the hats of both police and prosecutor." Is she correct?
That is correct, except for the contention that there's a conflict. Again, like I said, this is not a novel concept. It's exactly what the FBI and DOJ does. It's exactly what happens in all these RICO complex cases, white-collar cases, a number of complex litigation at the federal level. It's not a novel concept.
Okay.
Yeah.
Let's continue with this idea of conflict of interest. Police officers can get in trouble with the law in lots of ways, correct?
Yeah.
They can use excessive force, they can be corrupt, they can assault someone when off duty, they can physically abuse their girlfriends. In short, police officers can get in trouble with the law in the exact same ways that any citizen can get in trouble with the law. Isn't that accurate?
Yes.
But this bill, which allegedly is founded on conflict of interest concerns, is limited to situations in which a police officer is involved in an incident in which a citizen dies or is likely to die. Doesn't the same conflict of interest arise in other cases in which a state's attorney must decide whether or not to prosecute an officer with whom the office has worked closely in the context of other prosecutions?
So given the history of this nation, given the uprising, given the attention that we've paid to ensuring that our relationships between our communities, particularly communities of color, and the police are restored and elevated, when you have a death or an incident that's likely to occur in death, and you have the history that we do here in Maryland and across the nation, I'd say that there's a distinct difference between that and the cases that you've outlined.
Okay. So let me discuss with you where we're going here. For over 230 years, Maryland state's attorneys have had the responsibility of prosecuting all crimes taking place in their jurisdictions, and specifically all crimes committed by police officers. 2 years ago, following the George Floyd murder in Minneapolis, this General Assembly granted to the Attorney General the power to investigate situations in which someone either died or was likely to die, in which a police officer was involved. And now this bill seeks to remove from Maryland state's attorneys and grant to the Attorney General all power to prosecute in those cases. Next year, should we expect yet another bill to remove from Maryland state's attorneys the power to investigate and prosecute any other crime allegedly committed by a police officer?
No, I think this body has been extremely restrained in making these types of moves. So you'll remember, or you may not remember, but when we had this debate back when the Office of State Prosecutor was being debated, and it went up to court and it was challenged, and then this body passed a referendum. It went to the people of Maryland, passed, and the next year we passed the bill to create the Office of the State Prosecutor, because we felt that those cases needed to have an independent entity, a different entity, investigate that public corruption. It's the same here. there's an urgent need, and we have been extremely restrained in exercising that power in terms of taking things from the state's attorneys and saying, hey, look, this is a little different. We've got a little bit of a different history here, and we've been extremely restrained in doing that. In fact, we've only, to my mind, we've only done it twice.
So you're saying this is not a camel's nose under the tent situation, that if a bill comes up in a future year, I can quote you to the effect that this is not a camel's nose under the tent, this is a unique situation.
You can quote me in saying that I think we've exercised sound and wise judgment in this body, and we've only done this twice. Well, once. This is the second time.
All right. Have any other states enacted a statute like this?
Yes. 9 states have.
Okay. What are the 9 states?
So here we go. So the state's attorney general has original jurisdiction over criminal conduct by police in Montana, Connecticut, and New York. So the AG may but is not required to prosecute the cases, has the discretion to allow the local prosecutor to handle those cases or assign the cases to a prosecutor outside of the jurisdiction. In Vermont, Utah, South Dakota, South Carolina, New Mexico, Massachusetts, California, the state AD has concurrent authority with local prosecutors with some full discretion to intervene in the cases. And then in Arizona, Illinois, Colorado, Tennessee, and Iowa, the AG lacks original jurisdiction and may conduct investigation and prosecution only at the request of the political entity.
Okay, I said statutes like this. This statute removes from the state's attorneys all power.
The most akin, Minnesota, Connecticut, and New York are the most like what we're doing here.
All right, let's move on. The various states' attorneys' offices across the state are filled with experienced prosecutors. Wouldn't you agree?
I'm sorry, say it again.
The various states' attorneys' offices across the
Yes.
state are
Yes,
filled
yes, yes.
with experienced prosecutors.
Yes.
They've prosecuted literally hundreds of murder cases during my active years as a practicing attorney. So their level of experience in this regard is second to none, correct?
I'd say they are a high degree of competency, and yes, they're highly qualified folks.
Okay. Are you aware of any instance in which the Maryland Attorney General has prosecuted a murder case?
I'm not.
Are you aware of any prosecutors on the staff of the Maryland Attorney General who themselves have had any experience in prosecuting murder cases?
Officer involved deaths, yes, and I read that earlier in the kind of the colloquy between the senator from Harford County or Carroll County, and I can reread the letter that the Attorney General submitted to our committee in response to this line of questioning, if you'd like. But yes, they do have experience.
In prosecuting murder cases? In Maryland?
In the office, yes.
In the office, okay. Do you agree that someone prosecuting murder cases needs special training?
Yes, and experience gained over time.
Let me read you a portion of the statement from Mr. Gibson, the state's attorney in Howard County. He said, "The state's attorneys of Maryland have tried countless homicide and attempted homicide cases, which far exceeds the experience in these types of cases held by the individuals of the Independent Investigations Division of the Attorney General's Office. By passing this law, would we be doing a great disservice to our citizens by having less experienced individuals making charging decisions in these cases and further potentially prosecuting these cases?" Do you agree with that?
No. I mean, look, I think collectively they're going to have more experience because there are more of them, but the folks that are in this office have superior credentials, experience, are highly talented and competent, and I put them up against anyone in the state and in the nation. So I just simply disagree with that.
Senator, just a quick interruption here. Just a reminder to please make comments to the chair and to refrain from using you, he, she. It's the senator from X, the senator from Y, so that we can get to the not a deposition, but a debate, deliberative debate. Thank you.
I should direct my questions to the chair, and then you'll repose them to the floor leader?
The senator will listen to it as the senator is reflecting the question.
All right, Mr. President, how many additional employees will the Office of the Attorney General need if this bill becomes law?
I was literally just looking at that. So it's only two new. So at the inception here, this is what I was looking for earlier. So at the inception, the IID only had 2 employees, a division chief and a chief investigator. Over the past 2 years, the division has grown to include 5 attorneys, 8 civilian investigators, a paralegal, a victim and a witness coordinator, and a public information officer. So with this reform, you'd only need 2 additional attorneys.
And Mr. President, how many of those staff members have experience in prosecuting murder cases?
Well, so they don't exist yet. I mean, we got to go get those folks. But you're talking about the new people that are coming in, or the?
How many new people will they? Excuse me, Mr. President. How many new people will the Attorney General have to hire?
We'll do some professional development here. So the question is the senator aware of the number of specific? It is avoiding direct address. It is to say, is the senator aware, as opposed to, are you aware? Senator may rephrase.
I'd be happy to rephrase. So, Mr. President, is the senator aware of how many additional staff members the Attorney General will have to hire?
2, and 4 of the 6 current have murder experience here in Maryland.
Okay. Based on the report issued by the Attorney General, based on his investigations last year of police-involved deaths, Mr. President, 23 of such deaths occurred during the course of the year. No prosecutions of officers involved in such deaths have been initiated by state's attorneys. How many, is the senator aware of how many of these officers the Attorney General believes should have been prosecuted?
I think that's an impossible question to answer, because it's not, that decision does not reside within the Office of Attorney General yet. But the point is, having not been familiar with every individual case that's been there, that you've got the information before you, the fact that no state's attorney has moved forward, I think speaks for itself. That the facts were conclusive, and that they chose not to move forward, and that's it. So I couldn't tell you how the Attorney General would move forward with a case that they haven't seen before.
Mr. President, isn't it a fact that the Attorney General at the hearing on this bill was asked how many of those officers he would have prosecuted if he had had the power, and he declined to answer the question?
Senator, it sounds like that was not a question. That sounds like it wasn't itself.
That's correct, but it's literally impossible to answer that question. I mean, how could you answer that question when you're not the one in the seat making that decision?
Mr. President, my understanding is that the Attorney General for the last 2 years has been exclusively conducting the investigations. Who would be in a better position to decide who should be indicted and prosecuted than the person who conducted the investigations?
It's also an inappropriate question to answer, because if that decision currently resides within the state's attorneys, it would be inappropriate for the Attorney General, who does not have that ability or power yet, to then make a decision and a judgment on something that a current state's attorney is doing. It would be wholly inappropriate to comment on that.
So Mr. President, is it possible that if the Attorney General had had the power this bill seeks to give him, that he would, during the last 2 years, have not handed down any indictments of police officers? Isn't that possible?
So so it sounds like the senator is making a debate on the senator is welcome to debate the report. It doesn't sound like there's questions. The senator does not need affirmation of questions that both were sitting in the hearing. So if the senator wants to make a debate on the argument on the floor report, the senator should feel free.
Mr. President.
Yes, Chair recognizes the minority leader. What purpose does the senator rise?
We all need to vote on this, and I don't think all of us were in the committee to hear some of these questions that have been asked and answered. So I think it is appropriate that we are able to hear these.
Certainly. Thank you, Senator. The point is that the debate, Senator is more than welcome to debate the report and offer up all of the information. Asking questions for isn't it so just doesn't further the debate. So I would encourage the senator, if there are questions, genuine fact-based questions from the hearing, please proceed. If it is just making an argument, would just encourage the senator to focus the argument on the report, which is more than appropriate.
Okay. Thank you, Mr. President. I may go on. Do you agree that it's an article of faith among trial lawyers that in order to represent your client most effectively in court, you need to know your county, you need to know the citizens of your county who will be sitting on the jury, you need to know the ways of the court in the county, and most importantly, you need to know the judge who will be presiding over the case?
No. People appear before judges they don't know all the time. Also, the Office of State Prosecutor does this every single day. There are several divisions within the Office of the Attorney General that also do this across the state in all 24 jurisdictions every day. But that's also a feature of their recruitment. The Office of the Attorney General has stated that they will try to recruit diverse staff, not only ethnically and gender-wise, but also geographically, so that people have some familiarization. But that's not a prerequisite for success, nor is it even a crime. This happens all the time within the state's Office of the State Prosecutor and also within several divisions within the Office of the Attorney General.
So, Mr. President, at this point, if I could, I'd like to read a sentence by Judge Wanda Hurd, former judge of the Baltimore City Circuit Court, who testified quite forcefully in our hearing. And she said, an experienced trial prosecutor knows that in addition to legal knowledge and their trial experience, knowledge of the jurisdiction and its people who serve its jurors is essential to every prosecution. I wonder if the floor leader would care to let us know whether or not he agrees with that statement from Judge Hurd.
No, I think it's helpful, but not obviously a prerequisite for success. And you'll remember when I then posed the question about the office of the attorney of the state prosecutor, she had no rejoinder. I mean, because that's an office that's been functioning at a very high level for a very long time with no problem going to all 24 jurisdictions and having success. So, yeah, for what it's worth for the rest of the body.
All right, so, Mr. President, let me ask this question. How is it going to work if a squad of hotshot lawyers from the Office of the Attorney General in Baltimore City were to descend on, let's say, Somerset County, where the state's attorney is resentful that his power to try the local police officer has been taken away from him, where the courthouse staff is resentful that these lawyers are coming from Baltimore City to take over, where the presiding judge is equally resentful, and where the local press has prepared the local citizenry to be resentful about this prosecution. In your view, does that set up a situation in which the Attorney General is going to be able to effectively try and win the case?
No, again, I mean, I just go back. It sounds like a great John Grisham novel, but it just wouldn't. It wouldn't happen, and it doesn't happen in actual practice. It doesn't happen now with the Office of State Prosecutor, and it doesn't happen now within. Again, I'm just going to say the same thing over and over again. Several divisions within the Office of Attorney General operate through all 24 jurisdictions under circumstances just like you described, and have had no problem with this.
Okay. Mr. President, I've reached my last series of questions. You'll be happy to learn. So let me ask the floor leader whether he recalls that in his testimony before our committee, the Attorney General told us that his public position that he espoused on the campaign trail last year was that the state's attorneys should get first dibs on prosecuting police officers where a citizen death occurred, and that only if the state's attorney in the county where the death occurred were to decline prosecution should the Attorney General have the power to initiate a prosecution. Isn't that what he told us?
So I am uncomfortable parroting back. You know, if you have received that from the record, I'm uncomfortable speaking for the Attorney General here. But here's one thing. When we did the independent investigations, I was the sponsor of that bill. The Attorney General was not the Attorney General at that time. He was a member of Congress. And when I'm the sponsor of this bill, the Attorney General is not the sponsor of this bill. The body that decides whether this is the right course of action is the 47 senators sitting in this body right now and the 11 members of the Judicial Proceedings Committee. So I can speak for me as a sponsor and as the committee passed this bill overwhelmingly that this is the proper direction, and that the first bite of the apple, I think, still keeps the conflict infused in the reforms that we're trying to complete here.
So, Mr. President, it is correct, is it not, that once he was elected, the Attorney General, who came and testified very strongly in favor of this bill, reversed course, changed his position 180 degrees, and decided that the state's attorneys should be divested of all of their powers in this regard, and that the Attorney General should be vested with the entire power to decide whether or not to prosecute a police officer for a citizen death.
So it looks like maybe the state's attorney from Baltimore City and the Attorney General have swapped positions in this case. Then I'll give you the 1-for-1.
Okay.
Look,
well, let's come back to what I said earlier.
More seriously, I can't speak to what the Attorney General said before. I can only say that the Attorney General has been very clear in his support for this reform.
Okay. So, but he wasn't last summer when he was campaigning for election, was he?
If that's your contention, I can't speak to that because I'm not familiar with that. Honestly, I'm not.
Well,
but I trust what you're saying is correct.
Okay, that's my recollection from the hearing. So it's fair to say that there's not a single state's attorney in the state of Maryland who supports this bill, correct?
That is fair to say.
So in Prince George's County, Aisha Braveboy opposes the bill. In Anne Arundel County, Ann Colt-Litis opposes the bill. In Charles County, Anthony Covington opposes the bill. In Howard County, Rich Gibson opposes the bill.
Senator, if we could just refer from direct names on the Senate floor. If we could talk about the office,
okay.
The office.
Let me rephrase that. So the state's attorneys in Prince George's County, Anne Arundel County, Charles County, Howard County, Baltimore County, and Baltimore City all oppose this bill, correct?
That's the testimony received, yep.
Okay. So, do you know whether the Attorney General has sat down and met with the state's attorneys to discuss this bill?
Yes, but I am unaware of what happened in that meeting. But I'm aware that there was a meeting that took place. Yes.
Do you understand that the state's attorneys agreed with the Attorney General on this bill, or did they end up disagreeing? Are you aware?
Well, as is evidenced by your testimony here and then their letter, they disagreed. They had a departure of ways on that.
Thank you. Mr. President, when the time is appropriate, I have an amendment I'd like to offer.
Thank you, Senator. All right. Additional discussion on the report. And Senators, just as a point of clarification, the parliamentary procedure, the joy is to have non-emotional, impartial, thoughtful debate. And so the goal of having it not referring to you or the other is to ensure that there is thoughtful debate, that we're getting the facts out. It's not to stifle debate. It's to make sure that we do it in an impersonal way to keep the emotion. When we are emotionally legislating, it's our worst type. Chair recognizes the Majority Leader.
Thank you, Mr. President. Can I interrupt here for just a second with some visitors in the gallery?
Senator may proceed.
The Secretary of State, Susan Lee, and Lazarus Leadership Fellows from Montgomery County, led by Bruce Adams and Stephanie Clark, are with us today.
Welcome. Welcome. Thank you all for joining us. Thanks for being here. Yes, Chair recognizes the Senator from Frederick.
Mr. President, I just wanted to see if the floor leader would yield.
Senator may proceed.
For a few more questions. Thank you, Mr. President. Senator, are there, to the best of your knowledge, for state police involved shootings that result in this type of horrible outcome as well, which no officer wants to be in, this unit would investigate those state troopers? Is that correct?
So in these instances, so they already do investigate. So in these instances, there are protocols that have been developed. So when the office was stood up, the chief of the division as well as the employees went around. They engaged stakeholders throughout the state. So law enforcement agencies, impacted communities, community organizations, and developed a series of protocols that handle these types of situations. So the way that the investigations work now, MSP, the Maryland State Police, they assist with the investigation, the Office of Attorney General with these investigations. So if there's an instance, I think what you're describing, in which a Maryland State Police officer is involved, what they do is they have a conflict check, and an officer from another jurisdiction will come in and assist with that. So there's a whole line of protocol that has been developed in consultation with the Maryland State Police that they've employed, and I think it's happened maybe twice. And to 3 times. It's happened 3 times, and they've had great success resolving any conflict.
So it's kind of like the model that the current level state's attorneys use.
I wouldn't say that. I mean, they have a conflict, and then they have someone from another barrack come over and do it.
Kind of like other counties do when there are officers involved. They have another agency investigate, and they have another state's attorney.
Well, that's not the case. I mean, that's not the case for the lion's share of the cases, right? I mean, most cases are all done in-house. I mean, like I said, I've heard of a couple, maybe one-off MOUs. Howard County and Montgomery County have an MOU to do this all of the time, but the local jurisdictions are largely responsible for this.
Wouldn't that be important to know the actual numbers of that, though, Senator?
I'm telling you, it's one. One has an MOU.
Just a reminder, Senator, not you, the Senator. Remind the Senator.
Yes. 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 The Senator, yes. Senator.
So I guess my question then leads to, if the state police is investigating with this IID unit and they bring in another police officer, is there no liability perceived that the same body that is investigating this officer is also responsible for defending the state in subsequent prosecution or civil liability?
No, they're walled off, and they have I can read you a little bit. So these practices include utilizing MSP personnel who are assigned to a different region from the state, from the region where the trooper is involved happened. Also, in each case, MSP conducts a comprehensive inquiry to determine whether any personnel involved in the IAD investigation have actual potential or perceived conflicts of interest that might undermine the confidence in the impartiality of the investigation. And again, we have 3 investigations that have happened, one in Queen Anne's County, one in Somerset County, and I don't know where the third one was, but they've all exercised this protocol, and it's worked.
I understand that, and I appreciate that very much. I'm just curious, though, it still lends to the idea that the state, this body, the AG, which has always been for handling civil matters and defending the state's best interests, then becomes the defendant possibly in a future prosecution, or I'm sorry, lawsuit claimed or filed against the state in any said shooting. So my question is, doesn't that appear to be a conflict? Because I understand you're saying they're firewalled off, but at the end of the day, they still fall under the Attorney General. So that would be an apparent conflict, in my opinion, just by the fact that the same person who's responsible ultimately for the direction and that the prosecution goes is also the same person that's responsible for defending the state in any subsequent lawsuits for the same issue.
So you're saying, like, if there's well, no, I mean, yeah. I mean, I'm trying to figure out, like, are you saying there's a...
Is the senator saying?
Is the senator saying that there is a criminal conflict or a civil conflict?
Yes.
Yes, both.
Yes, because they both are hand in hand. If the IID is investigating a criminal matter involving a state police agency, a state police officer, and they find that there is potentially wrongdoing, or they find their findings are that there is potentially wrongdoing, then that same body, the AG's office, is then responsible for any subsequent prosecution, or I'm sorry, lawsuit, the defense of any lawsuit that comes forward. So they are running tandem for the same issue, one civil, one criminal.
So that situation in which, you know, the Attorney General is responsible for defending, like, an individual's rights, which doesn't, you know, happen. That situation happens all of the time. I'm just trying to figure out
the Attorney General's office.
If there's a conflict, like if the Attorney General, I'm trying to think of, like, for housing discrimination or something, which we're looking at right now. If the Attorney General were to bring a suit, a class of folks for housing discrimination, and the state were somehow implicated in that, then there would be, like, they would get outside counsel. But it just doesn't happen on that scale that you're talking about.
So you're comfortable with, as this is written, that if there's a police-involved shooting involving a state trooper, the trooper, that this investigative body finds that there is some type of potential issue, like they laid out on the one shooting in Baltimore from June of last year, that they want to say that now they're okay with being the representative body to defend any civil action that's brought against the state, while being a part of the investigative body as well. That seems inherently seems to be a really, really large conflict.
I'm sorry, Senator. Now I think I understand. The Attorney General would not be responsible for stepping in and representing the trooper in that instance. The trooper would have to seek outside their own counsel in that case. So there wouldn't be a
normally, aren't they defended by the state in a shooting? Aren't they defended by the Attorney General's office in a shooting civil matter?
No, I mean. No, they're not. I mean, they have their own attorneys.
So the state doesn't have any liability for training and the standards that police officers engage with, and they have no inherent liability for defending state police officers in an officer-involved shooting?
Senator, that's a different question. So the state, obviously, MPTSC and all those sets of standards for training. That's different than if an officer gets in trouble, they have to have their own attorney represent them. The Attorney General will not step in and represent the trooper.
No, but they represent the state.
State agencies, yes.
So they would represent the state in any legal action brought forward by the suspect in that matter.
In this instance, the Attorney General would not represent the trooper.
I understand that.
So there's
I'm saying that the state, the responsibility, the liability that the state has as a result of employing that trooper, the actions he takes based on his training and best professional guidance given, that the state ultimately has a liability to defend the actions of the officer from civil liability after it's been adjudicated criminally, if you want to. Sometimes, in Baltimore the other year, they adjudicated it prior to the criminal proceedings.
So if you're talking about like the state tort claims or local tort claims act, and like, you know, if there's the agency is now on the hook, then the state does represent the agency, but not that individual.
Correct. But the agency that they're investigating their standards, their training, their whole program goes into the background of investigating the officer in an officer-involved shooting. Because if they're not doing the proper training and preparedness, then is there not a liability associated with that?
So No, I get it. So I guess the clarification is that this office is not investigating like the training standards or the qualifications or anything that has to do with what got the officer on the front line. Their office is only responsible for investigating the officer-involved death of a civilian, or of an individual, rather. So there's no conflict there.
But it's relevant in the subsequent civil trial that follows said criminal prosecution. That same office, the AG's office, regardless of separate firewall departments, is irrelevant. It still falls under the Attorney General to have that discretion on how that is adjudicated.
Now I get what you're saying. So you're saying after this incident happens, then, okay, individual's going to go get their individual attorney, but then the agency is going to be on the hook for something if there's something wrong with training and all that stuff. That's
Correct.
a different entity within the Office of Attorney General that investigates that.
Or
that would defend that, rather.
Or what I'm saying is that if the officer acts within the correct threshold of that training standard, they are found justified. Civil prosecution or civil suit is wholly different on the threshold versus criminal. So can the officer not be, in theory, justified in his shooting, adjudicated appropriately? A civil suit is still brought against the state and that officer. So you're telling me in that situation that the Attorney General's office won't defend that officer for those actions that were deemed justified in a court of law?
It would not the officer, but the agency. They don't represent individuals. It would be the agency.
So they're going to represent the agency. So the officer would have to go out on his own and get his own attorney to defend from a civil liability stemming from his own training that is provided by the state. Is that what you're saying?
That's how it worked every single day that every member on the force, that's how it's worked. That's how
well,
it works
I understand
now.
that's how it works criminally. This is the first time I really think I'm hearing this, that that would work this way civilly. That there's no responsibility for the Attorney General's office to defend the state and the training standards that are in with their officers, and thereby pass along to their officers to defend them as well.
So again, a different entity within the Office of the Attorney General would defend the agency. Individual gets personal counsel, different burdens, criminal and civil. So yeah, I mean, you'd have a scenario in which maybe the criminal doesn't go forward, but the civil does.
Yeah.
Yeah.
I appreciate that.
That happens all the time today.
Okay, I appreciate that. Thank you. And then, to your knowledge, do you know on the composition you were talking about they were going to be adding investigators should this pass? Do any of those officers, or how many of those officers, to your knowledge, or is there going to be a standard that they have past experience as law enforcement officers, or that if they are previous law enforcement officers, that they are up to date on the most common training standards and practices within the law enforcement community? Because I can tell you that the training standards and practices have evolved immensely in law enforcement in the last 3 years on how we're handling things. So I'm just curious, is that going to be a component of this? Has that even been thought about?
No, it has. I mean, that's a discretionary exercise from the Attorney General and the Chief of the Division to ensure that the people that they're interviewing are up to speed on the law and on the current practices in law enforcement, and have the requisite experience and temperament to perform the job at a high level.
So no.
So yes, I mean that's what the Attorney General and what the Chief of the Division are going to be looking at, and it's a discretionary power.
But there's no standard to it. There would be no requirement to have someone that would have a field expertise to be able to provide that to a lay person. Like every other bill we move forward with, we always want to have stakeholders involved because they have unique experiences. But on this one, where people operate in a hyper-changing environment that is so rapidly evolving, most people can't wrap their brain around, and we're going to sit here and on the most important thing that we do, which is the protectors of our community, we're not going to have someone on that board as a requirement that has that background to provide that insight.
The position description, Senator, is developed at the discretion of the Attorney General and of the Chief of Division, just like all of the hires and fires are within that entity.
So again,
so there's
nothing that requires it,
nothing
and there's nothing that we're going to look to do to include that as a requirement, because this body can do that, because that hasn't been.
I don't know if we want to get into legislating, job descriptions and getting into that level of just rigidity and granularity. You have to, if you elect the Attorney General.
Yes.
People,
and we elect states attorneys.
That's true, Senator. And you give them the discretion to make their agency work. And so they have that latitude and flexibility to make that agency work. If you don't like the way it's going, then we get to vote them out in 4 years.
Okay. I appreciate your time. Thank you for your answering my questions.
All right. Question remains on the favorable report as amended. Chair recognizes Senator from St. Mary's on the report.
Thank you very much, Mr. President. Would the floor leader yield?
The floor leader yield. Senator may proceed.
Thank you, Senator. Just wanted to talk for a couple minutes, try to get a couple questions answered about this conflict in the relationship between the elected state's attorney and the officer that is involved. The officer that is involved in the actual situation where somebody dies or is seriously injured. And my question would be this, Senator. If in every situation that they would say that conflict exists between a police officer that's working in that county and the elected state's attorney, so the Attorney General would look at all of those.
So under this bill, the Attorney General would have the authority to prosecute every officer involved death of a civilian or every incident that was likely to cause death or likely to result in death of a civilian, all of them. So all of those cases.
And so the reason for that is based on the conflict that exists between, or the bias that is perceived between the elected state's attorney and the police officer.
That's right. It's sometimes it's an inherent conflict, but it's sometimes real and perceived. That's part of the purpose of the reform, is to instill trust, public trust in the process. And if there's a perceived conflict, then you're not going to have that trust in the agency that's supposed to be serving us. So real or perceived, it's functionally the same thing with respect to why we're here debating this reform.
So then I would go to the fact that if that police officer had worked in that area, in that county with that state's attorney for a long period of time, I could see that there might be grounds for something similar to this. But as you well know, police officers travel the state on a daily basis. So as a police officer traveling through a county that might have been the first time that they'd ever been through that county, they're involved in a situation that results in serious injury or a death. First time. They've never met another police officer that's working in that county. They've never met the state's attorney. Is what I'm hearing that just because they're a police officer, there is a bias that exists that says that local state's attorney cannot prosecute the case or investigate the case?
No, you're not. What you're hearing is that when folks work so close together, this is not about an officer or about a prosecutor in particular. It's when people work so close together and help develop cases together over the course of years, decades sometimes, there becomes an inherent conflict there. And so that's what this reform is really aimed at alleviating, real or perceived, to help instill and a level of trust in our system that we just haven't had before. So it's not about police officers per se. I mean, it's about the working relationship, which is not in itself, as the Attorney General said, inappropriate. It's just when it's placed in this context that it provides for an inherent conflict. that I think...
I definitely beg to differ. This is definitely about a police officer to say. But my question, Senator, is did the committee look at any potential amendments to say if that police officer is traveling through that county, that they had no relationship whatsoever, that they would be exempted from this, that state's attorney who prosecutes every other murder in that county, he prosecutes every other rape in that county, he prosecutes every other death in that county, he goes to the grand jury, but it's the first time that he's ever met this police officer, he says, wait a minute, the Attorney General's coming in, and the Attorney General says, that's because, Mr. Elected State's Attorney, your position has a bias with that officer that you've never met before. And that's my question. Did you look or evaluate that at all?
No, we did not have that amendment.
So I would like to switch gears just for a moment and ask this question. So when we talk about the conflict resolution and we talk about what exists between the elected state's attorney and that officer, and now that officer's worked there for 20 years, and we believe that this is a very valid issue, and there's a conflict that exists between that officer and that police officer, so that police officer doesn't get a fair trial. How is it then fair for that officer's testimony and his knowledge with that police officer, with the state's attorney, to prosecute other individuals? Do the vice versa. How is that then fair and doesn't create a defense for every person that is convicted in that county by that officer because of the relationship between that officer and the state's attorney? And I was just curious if you and the committee looked at that.
I'm not quite sure I understand, but no, we didn't. I mean, are you talking about, so if there's an officer that cannot receive a fair trial in their jurisdiction, is that then?
If
I
we
assume the
said,
attorney didn't seek to move
so
it to
Senator,
the,
if the
Senator.
So Senator, the legislation says that the local state's attorney would not prosecute, or potentially would not prosecute, the police officer to the full extent of the law without bias. Now, because of the relationship that exists between them. My question is, if that relationship is so strong that that state's attorney would not follow their elected responsibility and they would look away from the law, then how is it when that relationship then is used to prosecute any other person in that county for any serious crime, how is that not the reverse? How does this not create a defense for every single person if a police officer's worked in that county or has a relationship with a state's attorney?
I guess, so those other cases wouldn't, Senator, wouldn't involve law enforcement officers, but again, the relationship here is unique but not inappropriate in terms of developing cases, working with each other, kind of being in the trenches together time after time over the course of years and decades. That's just something that's different than if you were to prosecute, even in a small town, if you were to prosecute someone that everyone knows, having that working relationship is more of a conflict. I think that's the answer to your question, Senator.
Thank you.
Chair recognizes the senator from the 38th District on the report.
Thank you, Mr. President. Mr. Chair, I just wanted to ask...
Well, I just want to make sure the senator yield for a question.
I'm sorry. Will the
Senator may
senator
proceed.
yield for a question?
Mm-hmm. Senator may proceed.
Thank you. I wanted to ask that when the committee deliberated on this bill, which removes the authority from the state's attorney, and I want to put it a little bit in context. One of my state's attorneys from Wycomico County personally came up to testify, so concerned about the bill. And I want to point out that this particular state's attorney personally has prosecuted 2 law enforcement officers and ended up sending them both to prison without hesitation. And also her office right now is currently prosecuting a law enforcement officer. So just a context of where she's coming from. And in her testimony, it'll make sense why I'm asking my question. She went through and she said, prosecutors convict the guilty and protect the innocent. We do the right thing for the right reason every day. We are not motivated by political agendas. We make decisions, sometimes unpopular ones, based on the law and the facts. Ours is an honorable profession. We are accountable to our electorate. We are accountable to our communities. And when she testified, she really thought that removing this power from the state's attorney is a message even to the people that these state's attorneys can't be trusted with this authority, something they've been elected by their local voters. And my question is, as the committee deliberated on removing this authority from the state's attorney, did you discuss what the impact might be on negating the will of the electorate?
Thank you, Senator. Yes, this did come up, and it was, I think, a very good topic of discussion. And like I said earlier, some instances, some cases just arise to this level that you have to take this type of action. And like I said, it's only happened once, which was the creation of the Office of State Prosecutor. But there is political accountability here as well. The state's Attorney General is also elected, though at a statewide level, elected for a 4-year term and can be held and will be held accountable for the decisions that, in this case, he chooses to make. So there is a level of political accountability. At the same time, it's removed enough to not be swayed by the political whims that could affect impartiality, and also the personal relationships that could affect impartiality. We talked about this, and I'll just speak in abstract. Some states' attorneys would want to retain this power because it's politically advantageous for them to go after law enforcement officers. In the converse, others may want to retain this power because it's politically advantageous to shield officers from this type of prosecution. And so, there's politics, there's conflict, all kind of enmeshed. And I think as thoughtful policymakers, we considered it and thought that this was the right course of action because it balances out the political accountability, it removed the politics, it was removed enough from the on-the-ground politics, and provided the citizens of Maryland with a level of comfort knowing that there's an independent agency that's going to do these investigations and, if necessary, the prosecutions, and that that there would be no conflict. So it's not to say that the state's attorneys are not excellent, because they are. It's not to say that we don't appreciate what the state's attorneys do, because we do. And I put them up against any 24 in the nation. They're the best that we've got, the best in the nation. And I'm actually friends with quite a lot of them. So this is awkward. But it's ultimately, in balancing all of these things, it's we thought this is the right direction to go. So yes, we did have a fruitful discussion and ultimately decided upon this course of action.
And I appreciate that. In my district, and I don't know about everybody else's district, but I know in my 3 counties, there's an expectation of the voters who voted for those state's attorneys that they're going to do their job. They're going to prosecute if it warrants it. So my constituents are viewing this as, why are you taking away this authority from these honorable state's attorneys? And Mr. President, just a point of context, if I could.
Sir, you may proceed.
The reason this discussion, colleagues, is especially hard today is that my constituent, Maryland State Police Sergeant Brooks Phillips, a 19-year veteran, was shot last night on Route 50 on the western part of Wycomico County. And he pulled over a car driven by a violent offender on probation for gun charges with 2 passengers. And Sergeant Phillips was shot 3 times, 2 in the chest. He was wearing a life-saving vest, and he has been released from the hospital, thank God. And this incident went on that the driver sped away. He dropped off the 2 passengers. The 2 passengers get out. They end up running in Hebron, my colleague's district. The 2 passengers were eventually apprehended with a law-abiding citizen with a gun and taken into custody. The driver, the suspect, ended up driving to Del Mar and self-inflicted gunshot wound, and he is dead. And I wanted to share with my colleagues that it was important for me to personally speak to Sergeant Phillips this morning, and he is home with his wife and his 13 and 5-year-old sons, recovering and reflecting. And it just, again, point of context, Mr. President. So, coming up here this morning and, having to debate this when we've had, one of our own, my constituent, shot by a repeat offender out on probation with gun charges is very difficult. So these are the questions I'm asking, especially since I know my state's attorneys in all 3 of my counties. It just is very hard to see that we would be taking this authority away from them.
Thank you, Senator. On the report, further discussion on the report. If not, question is on the report. All in favor of the report say aye. Opposed, nay. The ayes have it. The favorable report as amended is adopted. Senator has an amendment. Senator recognizes the senator from the 42nd District. Actually, Senator, just let us distribute it. Pages, if we could quickly, efficiently get these out.
Thank you, Mr. President. This amendment is a couple of pages long, but easily described. So as...
Just give us one moment. Let's just get it out. Please, if we could please be efficient and get the... Thank you very much. All right, Senator may proceed.
Thank you, Mr. President. As indicated, this amendment is it's a couple of pages long. It's two pages plus a paragraph, but it's easily described. This amendment would put into effect the policy determination that the Attorney General campaigned on last year. The Attorney General went to most counties in the state. He did not say he wanted to take the powers away from their state's attorneys. Instead, what he said was the state's attorneys ought to have first dibs on prosecuting these cases, and if they failed to prosecute, then he should have the second chance, the second bite at the apple, to initiate a prosecution. Now, the one additional factor in this is that if the state's attorney should decide to prosecute, but for charges involving a penalty, involving less prison time than the Attorney General's charges that he wants to bring, the Attorney General would get to bring the case. But if the state's attorney wants to prosecute and level charges against the police officer, which carry with them at least the same amount of prison time as the charges that the Attorney General recommends charging them, then the state's attorney would get to prosecute the case. It merely would implement the proposal that the Attorney General argued to the voters all last year when he went from county to county campaigning. So that's the sum and substance of the amendment.
All right, Senator moves the amendment. Let's hear from the floor leader on the amendment.
Thank you, Mr. President. Could I ask the senator just a question, point of clarification for the amendment?
Will the senator yield for a question, the maker of the amendment?
Certainly.
Sir, you may proceed.
I didn't see this in here, and I don't know if it's because I don't have the bill, the delineated copy of the bill, but this doesn't change the timeline for investigations and when the investigations have to be given to the...
No, it doesn't affect investigations at all. There are some timelines in here as to when the Attorney General gives the results of the investigation to the state's attorney, how long he or she has to consider them before deciding what charges to bring.
Thank you.
So there are some timelines, but they don't interfere with the existing timelines on the investigation.
Excellent. So 45 days. Thank you, Senator.
Sure.
So I would ask the body to resist the amendment because it frustrates the entire purpose of this reform in the first place. First, one thing is that it would be unique to give two separate entities an opportunity to prosecute a law enforcement officer. That seems almost. I mean, I don't know how folks would support that, but you'd have in this case you'd have the state's attorney, and then if the state's attorney declined, then the attorney general could then still pick up the case and move forward. So you have two bites at the apple to prosecute an officer. So I don't know how law enforcement feels about that. Secondly, there are a number of the relationship between the state's attorneys and the attorney general. It just gets completely complicated. Let's say the attorney general furnishes the report. It then goes to the state's attorney. The state's attorney maybe charges or undercharges. There's nothing that the attorney general can do if they decide that, hey, this actually warrants a higher charge. There's really nothing that can be done. So it creates confusion. It creates tension. It's unnecessary, and it frustrates the purpose of the reform.
Mr. President, if I could respond.
On the maker of the amendment? Yes. Senator, may proceed.
First, let me just make the point. I'd like to have a roll call vote on this.
Thank you, Senator.
I disagree that this creates confusion. It specifically provides that if within 45 days after receiving the report and recommended charges of the Attorney General, the state's attorney shall notify the Attorney General of whether the state's attorney intends to prosecute the case and what charges, if any, the state's attorney intends to pursue. And then it goes on to say that the Attorney General may prosecute the case if there are two situations. Number one, the state's attorney declines to prosecute, or two, the charges pursued by the state's attorney carry a lesser maximum sentence of imprisonment than the recommended charges provided under section such and such of this subtitle. So it's not at all complicated, and it's not at all confusing. Thank you.
I beg to differ. I just think, if there are charges that are brought and then they do not pursue these in charges, then it would be extremely difficult for the Attorney General then to pick up and say, well, you should have done this. I'm going to go forward with this. I think it's extremely confusing. So I'd ask the body to reject.
All right. On the amendment, Chair recognizes the minority whip on the amendment.
Thank you, Mr. President. Just speaking in favor of the amendment, this is actually an extraordinarily good compromise to deal with what doesn't seem to be a widespread problem, but it's a priority for the Attorney General, and look forward to this kind of dedication to figuring out how we can better prosecute more criminals, but this in a widespread way. But when there is this kind of question about a police-involved death, then this would be a great compromise to not remove that local autonomy, at least on the front end, and give our elected state's attorneys, who've done by and large do an outstanding job, make sure they have first bite at the apple, and then involve the Attorney General afterwards. So I think it's a great amendment, and I'll be voting green. Thank you, Mr. President.
All right, on the amendment, any further discussion? If not, the clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 30 votes in the negative, the senator's amendment fails. Do we have other amendments? Any further? Chair recognizes the minority leader. Senator has an amendment.
Thank you, Mr. President.
Pages will collect the senator's amendment. All right, just give us a moment to get it up on the board here. Thank you. All right, Senator may explain the amendment.
Thank you very much, Mr. President. As you're aware, this Division for Independent Investigations was created in the 2021 legislation. I think it was Senate Bill 600 that created this division. There's been a lot of conversation today about political accountability and there is one individual in this entire process that is not accountable to either the voters or anybody else, and that is the leader of this independent investigation officer. So this bill simply says that the Attorney General shall appoint a director of the division with the advice and consent of the Senate. So that brings all of us involved, that we are able to question and confirm this appointee that is leading this newly created division. So I move the amendment.
All right, Senator moves the amendment. Let's hear from the floor leader.
So I'd ask the body to reject this amendment. The Attorney General is obviously elected, but needs the latitude to hire and fire their chiefs. And so there are over 10 divisions that are like this in size and function, not for the subject matter, but there are more than 10 of these divisions, none of whom are appointed by the governor or confirmed by the Senate. So I'd ask the body to reject this. This is no different than how the office functions now. The Attorney General needs the latitude to be able to move people around, to hire and fire them as they see fit. They're politically accountable to all of us. So.
All right, on the amendment, any further discussion? Anyone who's not yet spoken wishes to speak? If not, Chair recognizes the maker of the amendment.
Thank you, Mr. President. Again, this is an appointee of the Attorney General, not of the governor. Right. And again, it does give that individual the latitude to appoint who they want, but it does give us the ability to have some say in the matter. And there is an individual within the AG's office that does come in for advice and consent of the Senate. So this is no different than how it is the People's Insurance Council comes in for advice and consent of the Senate. So again, this is nothing that is outside of something that we don't already do, but again, a newly created division from 2 years ago, and I think it's very important that we are able to have some opinion on the selection of this individual.
All right. Any further discussion on the amendment? Any further discussion? If not, on the amendment, all in favor of the amendment? Senator requests a roll call vote. Clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone should change their vote, explain their vote? If not, the clerk will take the call. With 28 votes in the negative, the senator's amendment fails. Close one. Chair recognizes the senator from Southern Maryland.
Thank you, Mr. President. During the debate, colleagues, we heard that the committee had not addressed the fact about whether or not the police officer in question ever even knew the state's attorney. We discussed it. They never even discussed if there was a relationship. But this legislation says there's a perceived bias just because they are a police officer. I think that that is not exactly the way that I think that the legislation or the way that we should operate as a body.
I'm sorry, Senator. Does the Senator have an amendment?
I'm requesting a special order.
Senator, we don't have anything before the body to special order. So if we had an amendment, we would, but if we don't have anything before the body, it's open to amendment currently. Are there any further amendments to the bill? If not, any further amendments? If not, Senate Bill 290 is hereby ordered printed for third reading. We'll take it up at the appropriate time for third reading. All right, we've got another calendar here of report number 11. Clerk will read the first bill.
Senate Bill 269, Senator Rosapep, cryptocurrency campaign finance prohibitions, disclosures by financial institutions favorable to amendments.
Chair recognizes the Vice Chair of the committee as the floor leader.
Thank you, Mr. President. Somebody wants to give money to a candidate and they've got some extra lira or some stock or some shekels, and they can't donate that way. They have to change it into dollars. Same thing is going to happen if we move this bill that passed unanimously in terms of cryptocurrency. Folks have to change it into dollars and then obviously continue its transparency. This bill had two amendments that basically did what I suggested. The first one is technical, and the second one just clarifies and prohibits anyone from making a monetary donation using any currency other than American U.S. dollars. With that, I move the favorable report with two amendments.
All right, floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 269 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 379, Senator Kagan, Election Law, Ballots, Processing, and Reporting Procedures, favorable with 1 amendment.
Chair recognizes the Vice Chair of the committee as the floor leader.
Thank you, Mr. President. Those of you who were here last session would remember this bill that passed, was sent to the governor, and was unexpectedly vetoed. You may remember that we waited 4.5 weeks after the primary in order to get our election results certified. And that was because of the delay in processing mail-in ballots. Now, when mail-in ballots were 3 or 4% of the total vote, it didn't matter much. It didn't have that big an impact. But we're talking about an increased percentage, 25, 30, 35. It's going up, and we expect that it is likely to continue to increase. Maryland is unique in that it is the only state that prohibits the processing of mail-in ballots until after Election Day. And I can tell you that our voters are used to being able to find out who wins on election night. So this bill is essentially the same, but not identical to that which we passed last year. So I just want to flag a couple of the differences. So first off, it mandates, it's a shall rather than a may. It requires jurisdictions to start processing, start reviewing mail-in ballots 8 days before Election Day, before the start of early voting. And what that means is they can look at the ballot, they can see whether someone omitted their signature and therefore give them an opportunity to cure the ballot so it's counted. It also enables them to literally take the ballots out of the envelopes, flatten them, batch them, put them in piles. It also enables them to start putting through the scanner. It does not allow them to start tabulating. There will be no totals, there will be no temptation, there will be no leakage of early election results. So it just allows the processing. And on Election Day, they can start tabulating so that on election night, early voting data and mail-in data would both be able to be posted and shared. The few things that are different from last year, so one is that it is a shall. There was, most of the large jurisdictions did do the early canvassing. Unfortunately, Anne Arundel's board voted not to, and with close races there, it meant quite a long delay, which fostered and enhanced some of the conspiracy theories. So that's not what we want. So there is an opportunity to ask for a waiver. So if you represent Garrett County and there are 100 mail-in ballots, it doesn't make sense to rent a hall, hire the people, turn on the cameras, live stream to do 100 ballots. That makes no sense. So Garrett County's election director could write to contact the State Board of Elections administrator, ask for a waiver, and that would be granted. We made clear, sort of based on the numbers or any other circumstances, extenuating circumstances, that could be waived. Other than that, the largest jurisdictions really will be canvassing. Second, we talked about last year just making sure, and it's tighter, which ballot would be counted if someone, let's say, had a mail-in ballot and then went and voted in person, which one that would be counted. It also talks about precinct reporting, which I think we all care about and advocates and political parties care about. So those are some of the issues that are covered in this. The amendment that the committee added to the bill simply clarifies, sorry, this is one more thing. One thing that I did add to this year's bill is there was a delay in logging in the mail-in ballots. And so people were starting to get worried. Maybe their ballot got lost in the mail. So it says as soon as possible and not longer than 2 business days if it's a regular mail-in ballot. The Maryland Association of Election Officials asked for a little bit more time for the very cumbersome, challenging, difficult internet-delivered ballots. So part of this amendment says that for internet-delivered ballots, that they have up to 4 business days. We still wanted it to be within 1 business week, so voters can be confident that their ballot has been received. So with that, I move the favorable report with the 1 amendment on this bill.
Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the committee amendment, any discussion? Chair recognizes the senator from District 7.
Thank you, Mr. President. I do have one quick question.
Will the floor leader yield? Senator may proceed.
Happy to.
I have a lot of questions, but I want to read it first. But you had a bill about a week ago or 2 weeks ago, and I asked about the mail-in ballot, and I think it was the fact that at home, I print it out on my home computer, fill it out, put it in the envelope, I mail it back to the Board of Elections, and unfortunately, I guess the machine requires a certain type of paper, or it could be. I'm just trying to figure out if we've addressed that in this.
We're trying to address it a lot of different ways. In this one, the main aspect that we're doing is making sure, we talked about it in the recount bill, and just making sure that those are going to be accessible and maintained and stored in a way that's going to make recount easier and more efficient. In this one, we're talking about giving twice as much time for our local boards of elections to make sure that they can be logged in.
Okay. Mr. President, it's a pretty substantial bill. I was wondering if we could special order this so I could get some time to read it over tonight, if that's possible.
That's fine.
Senator, on a special order?
Absolutely. Thank you.
No objections to the special order?
Thank you, Mr. President.
Without objection, we'll special order the bill to the appropriate time tomorrow. All right. Clerk, read the next bill.
Senate Bill 382, Senator M. Washington, Accessory Dwelling Unit Promotion and Policy Task Force, favorable to amendments.
Chair recognizes the bill sponsors. The floor leader.
Thank you, Mr. President. SB 382 establishes the Accessory Dwelling Unit Policy Task Force, and it's going to be staffed by the Maryland Department of Planning. And the work of the task force is to study and review existing law, practices, and impact relating to accessory dwelling units, ADUs. ADUs are typically small home conversions. They're additions to your home. They have to include a private entrance, a kitchen, a bathroom, and a bedroom. They're also known as granny flats, carriage houses, lane houses, if it's on an alley, mother-in-law suites, etc. And they could also be in a basement, and they can be a garage conversion. And some of them are attached, and some of them are not attached. Now, there's no statewide law that sets requirements or governing ADUs. This is very much done at the local level. State law does, however, include that there's some authorizing of governments to determine the nature and the number. Why this is coming before us is that there are many who believe that ADUs can assist with the housing crisis that we have. There are others that are certainly concerned and want to make sure that the nature of stable communities, et cetera, is not disrupted. Therefore, we do what we do is to get all the parties together to have time to discuss it and to work it out. So there will be 2 reporting dates. One, December 31st at the end of this year to report what they're doing. Then a second reporting date that would allow for there to be action on this item should we choose. There are 2 committee amendments that address the concerns that were expressed during the hearing. One is a technical one. It changes the name of the ADU policy promotion and policy task force to simply removing promotion. Again, ensuring that this is a balanced approach and not necessarily assuming that we'll come out with a set of recommendations. The second specifies that urban, suburban, and rural communities should be looked at differently. The amendment modifies the membership of the task force and includes some additional members. It also ensures a balanced approach. Finally, the amendments remove the reporting dates up for the two mandated reports. I urge the adoption of the two committee amendments and the favorable committee report.
Floor Leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 382 is hereby ordered printed for third reading. All right, we've got a report, another Education, Energy, and the Environment. This is report number 12. Clerk will read the first bill.
Senate Bill 29, Senator McCray, Baltimore City Soil Conservation District Establishment Requirements, favorable.
Chair recognizes the President Pro Tem as the floor leader.
Thank you, Mr. President. Senate Bill 29 establishes provisions governing the creation of a Baltimore City Soil Conservation District pursuant to the authority provided under current law. Specifically, the bill establishes a formal mechanism for establishing the district as a government unit through certification by the Secretary of State and provides for the appointment of the 5 Baltimore City Soil Conservation District supervisors. There are no committee amendments. There's no fiscal impact. I move adoption of the favorable committee report.
Floor Leader moves for the adoption of the favorable committee report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 29 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 280, Senator Guile, Child Care Providers, Registration, Licensing, Exemptions, favorable to amendments.
Chair recognizes the Senator from Anne Arundel as the floor leader.
Thank you, Mr. President. We're always looking for ways to help Maryland be more friendly to military and their families, and this bill helps to do that. Specifically, this bill exempts a family care child home, large family child care home, and a child care center from the state registration and licensing requirements if the entity is 1, located on a military base or federal property, or 2, certified as a family child provider by a branch of the U.S. Department of Defense or the U.S. Coast Guard. There were 2 amendments. The first adds co-sponsors and makes technical changes. The second amendment provides that it exempts the Department of Defense and Coast Guard certified family child care providers serve only dependents of military personnel, and that they assume the responsibility of approving or determining which children are served by these child care providers. This passed unanimously, and I move the amendment in the favorable committee report.
Floor Leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendments say aye. Opposed, nay. The ayes have it. The 2 committee amendments are adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 280 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 491, Charles County Senators, Charles County Board of Education, School Bus Contractor Employees Negotiations, favorable to amendments.
Chair recognizes the Senator from the 35th District as the floor leader.
Thank you, Mr. President. As amended, this bill establishes the task force to study school bus operator contracts and wages in Charles County. The task force must include representatives from the General Assembly, the Charles County Board of Education, the Charles County Superintendent, and various stakeholder unions. There are 2 committee amendments. The first one makes technical changes to the bill's title. The second amendment establishes the task force to study school bus operator contracts and wages in Charles County. I'd like to move the amendments and for adoption of the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Chair recognizes the Senator from Charles County as an amendment.
Mr. President, going through the amendment, there's a technical issue, a minor technical issue. So could we hold the bill until tomorrow?
So we don't have anything before us in the body. We don't have a question before the body. The only option is to potentially reconsider the vote by which the favorable report was adopted. Does the Senator wish to make the motion?
Okay, yes, make a motion to
All right, Senator
reconsider
wishes
vote,
to
yes.
make the motion to reconsider the vote by which the favorable report was adopted. Chair recognizes the minority leader on the motion.
Thank you very much, Mr. President. But nice if that clarification was made a little while ago when.
Well, it's a fair point, Mr. Minority Leader. I was thinking through the answer to that to make sure that I was trying to think what the right motion would be. So, for what it's worth, that's as I'm sitting here with my rule book here going through. So that is the right motion. Okay. So, Senator wishes to make. Are there any objections to the senator's motion? If not, the motion carries.
Thank you, Mr. President.
The amended report is before the body. Now, the senator now wishes to make a motion, subsequent motion.
Yes, I move to special order the bill, Mr. President.
All right, the senator wishes to moves to special order the bill to the appropriate time tomorrow.
Yes.
Are there any objections? Without objection, so ordered. All right, clerk will read the next bill.
Senate Bill 846, Senator King, Library Circulation Records Inspection, Use, or Disclosure Requirement Revision, favorable.
Chair recognizes the senator from Frederick City as the floor leader.
Thank you, Mr. President. Our libraries respect our privacy by not disclosing our circulation history. What this bill does is it alters the circumstances under which libraries can release that information. They are threefold: for the reasonable operation of the library, with written consent of the individual, or by a subpoena or court order. This bill was voted unanimously. There's no fiscal impact nor amendments, so I move for an adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 846 is hereby ordered printed for third reading. I think that does it for that calendar. Let's move to budget and tax. We've got report number 9. Number 9, clerk will read the first bill.
Senate Bill 204, Senator Jackson, State Retirement and Pension System Vesting and Retirement Allowance, Clerk of the Court, Register of the Wills, favorable with 2 amendments.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 204, as amended, lowers from 10 years to 8 years the number of years of eligibility service that clerks of the Circuit Court and Registers of Wills need to vest in the employee's pension system. Also, it makes clerks of the Circuit Court and Register of Wills who begin membership in the employee pension system on or after July 1, 2011, eligible for normal service retirement benefits if they reach age 65 with 8 years of eligibility service instead of currently, what it is currently 65 and with 10 years. There are 2 amendments. The first is technical, changes the title. The second makes changes clarifying the prospective application of the bill and makes clarifying changes to provisions of law providing for vested benefits. Move adoption of the committee report.
Floor leader moves for the adoption of the 2 committee amendments in the favorable committee report. On the amendments, any discussion? If not, any objections? Without objection, the 2 committee amendments are adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 204 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 273, Senator Zucker, National Capital Strategic Economic Development Fund, authorized uses, favorable to amendments.
Chair recognizes the bill sponsor as the floor leader.
Thank you very much, Mr. President. Senate Bill 273 deals with the National Capital Strategic Economic Development Fund. As amended, what it does is it eliminates a sunset that basically keeps the status quo. One of the amendments adds co-sponsors, also increases funding to create parity on other programs like this statewide. The amendment is technical changes, adds co-sponsors, and then deals with the funding piece. I move the amendments and adoption of the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 273 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 636, Senator Gazzone, video lottery terminal proceeds, purse dedication amounts, Ocean Downs Racing Course operating loss assistance, favorable with one amendment.
Chair recognizes the majority leader as the floor leader.
Thank you, Mr. President. Senate Bill 361 alters and makes permanent the annual distribution to Ocean Downs Racecourse for operating loss assistance from the purse dedication account. Specifically, the bill authorizes an annual distribution equal to up to $30,000 per live racing day beginning in calendar year 2023. The bill also repeals the calendar 2024 sunset of the annual distribution to Ocean Downs Racecourse from the PDA. There's one committee amendment that adds sponsors, and I move adoption of the amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report on 363. On the amendment, any discussion? Any discussion? If not, any objections? Without objection, the one committee amendment is adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 363 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 442, Senator Quarterman, Economic Development, Sports, Entertaining Facilities, Financing, and Construction, favorable.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 442 increases the amount of bonds that the Maryland Stadium Authority may issue for sports entertainment facilities from $200 million to $220 million. The bill also allows a nonprofit organization that will own or operate a sports entertainment facility to request financing from the Maryland Stadium Authority and enter into a written agreement with the authority related to the ownership, marketing, promotion, maintenance, and repair of such facility. There were no committee amendments. Move adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 442 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 451, Senator Griffith, Procurement Improvement Council memberships, favorable to amendments.
Chair recognizes the bill not the bill sponsor. Senator from the 27th is the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 451 as amended as the comptroller as a member of the Procurement Improvement Council and authorizes the comptroller to send a designee to the council if the comptroller is unavailable to attend. The bill also clarifies the council's duties include strategies to increase the participation of small, minority-owned, and women-owned businesses in procurement contracts. There are two amendments. The first is technical to the title and adds a co-sponsor, and the second amendment clarifies the duties of the council. Move adoption of the committee report.
All right. Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 451 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 469, Senator Elfrith, Task Force to Study Solar Tax Incentives, favorable, one amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you very much, Mr. President. Colleagues, a few years ago, this chamber led the way in ensuring that we are utilizing renewable and making sure we have very aggressive renewable energy goals. But we have not looked at our tax structure to make sure we can actually meet those goals in a timely manner and an effective manner. Budget and Tax Committee every year sees a number of bills, kind of one-off bills incentivizing one form or another. We decided instead we want to take a step back, form a task force, engage all the stakeholders, including our local partners, to ensure that we are strategic in the way that we are structuring our tax code relating to solar energy. So the task force, as the bill is introduced, must study and make recommendations regarding a tax strategy that's more competitive than the state's current strategy to maximize the installation of rooftop solar panels, facilitate and promote installation of grid-connected generation of renewable energy, and meet the state's renewable energy goals. The task force is required to report its findings and recommendations to the General Assembly by December 15th, 2023. There's one committee amendment, Mr. President, that alters the membership of the task force, states that membership should represent the diversity of Maryland and incorporates community solar as part of what's required in the study. I move the adoption of the committee amendment, the one committee amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, Chair recognizes the minority leader.
Thank you very much, Mr. President. On the amendment, could the floor leader yield, please?
Will the floor leader yield? Senator may proceed.
Again, and I appreciate the efforts that we continue to try to promote solar in non-agricultural uses. But I see the membership of the board is created. Obviously, we have people from the House and the Senate, MEA, PSC, SSTAT, MACO, MML, and then individuals that are very specific to the industry, those that have worked on rooftops, worked on ground-mounted solar, community solar, struggling with the amendment, that all of a sudden we have to add individuals from organized labor. Why is that?
Those are the folks who are on the ground and actually installing, in many cases, what we're looking to achieve here. And then we had a request from the Office of People's Counsel to also be included. And then we had a nod to our former colleague from Western Maryland, the geographic diversity membership as well.
Right. So People's Counsel generally is concerned with, obviously, impact to ratepayers is one of the big charges from People's Counsel. But again, if we have people from the industry, what value does organized labor bring to this?
Thank you, Senator. I think the value that they bring is these are the folks who are making a living, hopefully a family-sustaining living, off of these projects and have an integral understanding of what goes in to make these projects effective.
Okay. Well, thank you very much. I appreciate it. Mr. President, I might add that I think that there are a number of different types of contractors that can make a living off of this. You know, could be merit shop contractors. It's not necessarily just organized labor. So I'd ask that the bill and the amendment lie over under the rule.
Senator's motion is in order. The bill and the amendment will lie over under the rule. Clerk will read the next bill.
Senate Bill 556, Senator Gazzone, Maryland Community Health Resources Commission, compensation of employees, favorable.
Chair recognizes the senator from Baltimore City as the floor leader.
Thank you, Mr. Senate President. Senate Bill 556 authorizes the Maryland Community Health Resource Commission, in consultation with the Secretary of Health, to set the compensation of commission employees in a position that is unique to the commission, requires specific skills or experience to perform the duties of the position, does not require the employee to perform functions that are comparable to functions performed in other units of the executive branch of state government. The Secretary of Budget and Management must consult with MCHRC to determine which positions the bill affects. No amendments. Move adoption of the committee report, Mr. President.
Floor leader moves for the adoption of the favorable committee report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 556 is hereby ordered printed for third reading. All right, we've got a special order calendar that's been hanging around with us. Are we ready? Yes. Clerk will read the bill.
Senate Bill 18, Senator West, Police Retention Work Group. Question is on the adoption of the two committee amendments and the favorable report.
The question is on the two committee amendments. Senator, do we have a subsequent amendment?
We have, I believe, two additional amendments, both of them which will be considered as friendly by the committee.
Okay, let's take up the two committee ones initially and the report. The question is on the two committee amendments. Any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the favorable report is amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Senator has an amendment. Pages will collect and distribute the.
Actually, Mr. President, I think the chair of the committee has the two amendments.
Excellent. Thank you, Senator. Chair recognizes the chair of the committee.
Thank you, Mr. President.
As one amendment. First amendment.
First amendment.
Let's give us just a moment to collect and distribute. All right, Senator may explain the amendment.
Thank you, Mr. President. So as you know, this is a police retention work group, and we consider this amendment to be friendly. What this does, it says that to the extent possible and that the information is available, we'll study the migration of police officers between departments, the attrition rates, employment rates, the number of actively employed police officers who have retired from other departments and at state and local government. We consider this a friendly and move for the adoption of the amendment.
Senator moves the amendment. Any discussion? Any objections? Without objection, the Senator's amendment is adopted. Senator has another amendment?
Yes.
Pages will collect and distribute the second amendment. All right, Senator may explain the amendment.
Thank you, Mr. President. So again, we consider this a friendly amendment. This is offered by the senator from Prince George's County. It makes a title change. One's kind of technical, just says police, it just inserts recruitment and retention in the title. And the second part of it, it speaks to that the work group will look into options of apprenticeship and attracting students who are in high school. It's kind of like what the Maryland State Police does with their Explorer program. So I'd move adoption of the amendment.
All right, the senator has moved the amendment. Just want to clarify that the amendment name is under the senator from College Park. If there's no objection from the senator from College Park, then we can have the committee chair move the amendment.
Apologies. Thank you.
Without
very much,
objections, the senator's moved the amendment. Are there any objections to the amendment or? So it is in the floor system. It is in the floor system. Let's just double check that we get this correct. It's in the floor system.
Mr. President.
Yes, Chair recognizes the minority whip.
Point of order for perhaps future discussion. I didn't know you could move an amendment not in your name.
There can be we can waive the objection. Technically, it is an objectable. It would be a motion that is subject to objection. The senator can waive his objection if the maker of the amendment seeks to have that done.
So is that one would make a formal request to waive? I'm thinking about situations later in session when we have lots of amendments and
It's a very fair question. It's a very fair question.
I have no objection. I just wanted to be sure that's something we can do anytime.
Certainly. So the issue why generally that's not the case is because amendments are confidential until they've been offered to the Senate. And so generally another senator cannot provide an amendment because it would release the privilege to the maker of the amendment sponsor. Technically, it is not public until it's been provided. So that's the real reason for the objection, but how it gets moved. So I mean, we can do it. Let's do this. Would the chair like to make the motion or withdraw the motion?
Mr. President, my apologies. I know it's unorthodox, so I'll make a motion to withdraw the amendment.
All right. The chair moves to withdraw the amendment. Chair recognizes the senator from College Park.
And I move the amendment.
Senator has an amendment that has been, and this is, let's just make sure we get it all correct. This is 893-227/1. All right. The senator has moved the amendment. We've heard an explanation. Chair recognizes the senator from the 38th District on the amendment.
Thank you. Yes, on the amendment. I just wanted to understand, because I know your original amendment had the recruitment in it that you talked about, and we adopted that. But the part about the statewide joint apprenticeship council then working with the high schools, I just wanted to understand that because I know with the blueprint we have work going on with the apprenticeships, and I also know that our superintendents are really overloaded with that, and I totally support this, but I just want to make sure this is set up in a way that there's complete coordination, and so that's why I actually wanted to see the amendment. I did pull it up, but I'd like to better understand that, the connection with the council and the high schools.
Yes.
Senator may proceed.
Thank you very, very much. Yeah, it is structured exactly that way because we have in the Kerwin plan high school level of registered apprenticeships. As the chair of the committee said, we already have high school programs with police forces, cadet programs. So this is designed to say, let's look big picture in your seatmates bill at integrating that all together, including exploring, not requiring, but exploring setting up a joint apprenticeship and training council among police agencies and police unions, the way they can work together to design a program that starts in high school that takes people all the way through the police academy and other police forces.
So this would have the potential to expand what we're currently doing with our partnerships with law enforcement in our technical high schools, and mine have that, which I strongly support. But this would allow this to go statewide then, as far as giving those local school jurisdictions the option to set up these law enforcement apprenticeships in their areas?
School systems already have the option to do this. This is more about the apprenticeship structure itself, because most of those high school programs right now are not part of apprenticeships. Okay. They're part of sort of unofficial official cadet programs, but they're not part of registered apprenticeships. And in the Kerwin law, the plan is to get 45% of our high school kids to be in registered apprenticeships by 2031. And so this is trying to jumpstart the exploration of how we do that in law enforcement for police.
Okay, so it builds on what we're already doing.
Totally.
Okay, thank you.
Thank you.
All right, further discussion on the amendment? Are there any objections to the amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill? Yes, Chair recognizes the Senator from District 6.
I have an amendment.
Has an
Mr.
amendment.
President.
Senator has an amendment.
Yes,
Give
sir.
us just a moment. We'll collect and distribute the amendment. This bill has been the Christmas tree of the session so far.
We have a bright spot in the Senate.
Give us just one moment, one moment. Very complicated one. Senator may explain the amendment.
It has a sponsor. Thank you, Mr. President.
Excellent. Senator moves the amendment. Any objections? Without objection, the amendment is adopted. We have another amendment. Chair recognizes the Senator from the 38th District.
Yes, Mr. President, it's a simple amendment to add myself as a co-sponsor.
All right, let's collect the Senator's amendment. We'll make sure we get it up on the board, and just double checking. This is why we read. Actually, I mean, this is why the paper is important. It's slow down. Gives us a second to read it. Every word matters. Make sure it's written to the right form of the bill. All right, we have the Senator from the 38th has moved the amendment. Any objections to the amendment? Without objection, the amendment is adopted. Any? For Chair recognizes the Senator from the minority leader is a
just a question.
Yes,
Mr.
Senator,
President.
proceed.
So we received the amendment from the Vice Chair of B&T.
Yes.
Correct? And then there was an amendment from the Chair of JPR. Have we heard that one yet, or is that
That was
not
the
being
first one
offered?
that was the first one that we did.
Okay.
It was adopted number 223. 223.
Thank you very much.
Mm-hmm. Any further amendments? Any further amendments? Fair enough. Fair enough. All right. If there are no further amendments, Chair recognizes the Vice Chair of the committee.
Senator, I'm just clarifying. There's another amendment on the floor that I understand that the committee considered but did not enact. It's in the system, so I just thought I'd check on that. It is not a part of the bill.
Not a part of the bill.
Thank you very much, Mr.
Thank
President.
you. All right. Senate Bill 18 is hereby ordered printed for third reading. All right. Off it goes. Thank you. Thank you. Thank you. Good catch. All right. If we could, let's see, do we have everybody? It appears so. Let's do a quorum call before third reading calendar.
Mr. President?
Has everyone recorded their presence? It appears so. Clerk will take the call. With 47 members in the chamber and a quorum being present, the Senate of Maryland remains in session. We have third reading calendar number 16. Clerk, read the first bill.
Senate Bill 120, Senator Lamb, Public Schools, Anaphylactic Food Allergies Guidelines.
Senate Bill 120 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 120 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 249, Senator Kramer, Motor Vehicle Administration Driver Education Program, Cannabis or Alcohol.
Senate Bill 249 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 249 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 266, Senator Watson, Maryland Consortium on Coordinated Community Supports Membership Alteration.
Senate Bill 266 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 266 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 293, Senator Sidnor, Corrections, Incarcerated Individuals.
Senate Bill 293 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 293, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 330, Senator Reedy, Public Safety Law Enforcement, Body-worn Cameras, Body-worn Camera Appropriation and Financing Act of 2023.
Senate Bill 330 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 330, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 435, Senator Klossmeyer, Property Tax Credit, Disabled Law Enforcement Officers and Rescue Workers, Definition and Eligibility.
Senate Bill 435 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 435, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 457, Senator Bailey, St. Mary's County Public Facilities Bond.
Senate Bill 457 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 457, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 458, Senator Bailey, St. Mary's County Bond Authority YMCA Facility.
Senate Bill 458 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. There it is. With 47 votes in the affirmative, Senate Bill 458, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 467, Calvert County Senators Work Group to study the fiscal and operational viability of public-private partnership for Calvert County Public Schools.
Senate Bill 467 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 467, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 718, Chair, EEE Committee Voluntary Cleanup Program, Determination and Recordation Deadlines.
Senate Bill 718 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 718, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 831, Senator Hershey, Libraries, Regional Resource Centers, Governance Requirements.
Senate Bill 831 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 831, having received a constitutional majority, is declared passed. All right, that was a lot. The desk is clear. Desk is clear. A lot of great work done today. Just a quick note. This is one that it's sort of one of my favorite descriptors of the legislative process. I know it can get a little bit annoying having the calling out of the senator this, the senator that, and all of the rules and trying to make sure. But there is a very important reason behind it. So one of the outlines, Mason's manual helps give some clarity around some of the rules if they're not in the rule book in Mason's manual. The purpose of legislative bodies is to reach the best joint judgment on the questions presented to them for decision. The decision is the decision of the group, not of the individual members. To reach the joint judgment of the body, the exchange of thought and reasons of the members is essential. And so that's the key, is that it is a group decision. It's not one individual's bill. It's not one individual's discussion or argument. It is the collective Senate of Maryland's decision. And so that's why the debate is so critical. It makes us a very, very, very unique space, and it's the fundamental value of our form of the branch of government. So that's why I know it can feel a bit ticky-tacky, but there's reason behind it. It's not just to enforce rules for the fun of it. All right, let's go to the Chair of Finance.
Thank you, Mr. President. Senate Finance will meet at 1:30 p.m. today in the committee room. We'll have bill hearings followed by a voting session.
Thank you, Madam Chair. Chair of Education, Energy, and the Environment.
Thank you, Mr. President. Triple E will meet at 1:30 as well for simply bill hearings, no voting today.
All right, thank you, Mr. Chair. Chair of Budget and Tax.
Thank you, Mr. President. We'll meet at 1:15 for voting, followed by bill hearings, which should not begin any anyway before 2, so it'd be no, it will not be before 2.
Excellent. Not before 2.
Right.
Excellent.
Yes.
All right. Thank you, Mr. Chair. Chair of Judicial Proceedings.
Thank you, Mr. President. The Judicial Proceedings Committee will meet for a voting session at 1:15, followed by bill hearings at 2:15. We have close to 200 witnesses today, so make sure you are fueled up for a long night.
All right. Thank you, Mr. Chair. Thank you, Judicial Proceedings members. Chair of Rules Committee.
Thank you, Mr. President. The Rules Committee will meet right after session here in the Red Room.
All right. Rules Committee immediately following. Thank you, Madam Chair. Any other standing committees, select committees, joint committees, delegations? If not, let's do a quorum call before we adjourn.
Mr. President?
Has everyone recorded their presence? So the clerk will take the call. With 47 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Chair recognizes the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Wednesday, March 8th at 10 a.m.
All right, without objection, so ordered. Have a phenomenal day, everyone.